Ladies and gentlemen, we begin this webinar in the next 30 seconds. Ladies and gentlemen, a very good afternoon to all of you and welcome to this webinar. My name is Ajay Thomas and I'm the Director of the Faculty of Law at Manav Rachna University. At the very outset, may I take this opportunity to thank all of you for your support to this initiative, which is the second in a series of Back to Basic webinars dealing with fundamental concepts relating to the practice of law. The first in the series of webinars was held on the 3rd of May, which was a masterclass on the fundamentals of pleadings with Justice Pradeep Nandrajog as the resource person. Today's webinar will focus on the fundamentals of examination in chief and cross-examination in a civil suit. And to take you through this nuts and bolts topic, we have with us a former Chief Justice of the Bombay High Court and a sitting judge of the Delhi High Court. And I must say that we are extraordinarily privileged to have both of these gentlemen with us today on this webinar. Most of you know these two gentlemen very well, but to those few of you who do not, here's a little more about our distinguished speakers. Our first speaker is Mr. Justice Pradeep Nandrajog, who recently retired as the Chief Justice of the Bombay High Court. Before moving to the Bombay High Court, Justice Pradeep Nandrajog served as the Chief Justice of the Rajasthan High Court for 2 years and as a judge of the Delhi High Court for more than a decade. Friends of mine who had the opportunity of appearing before Justice Nandrajog have had great things to say about his wit, his erudition, and mastery over matters relating to trials and civil procedure. Our second speaker for today is Mr. Justice Rajiv Sahai N. Law. With a surname like N. Law, it is no surprise that Justice N. Law has ended up being a sitting judge of the Delhi High Court. Justice N. Law did his LLB from Campus Law Center, New Delhi. He enrolled as an advocate with the Bar Council of Delhi way back in 1982. He was elevated as a judge of the Delhi High Court in 2008 after having served for more than 25 years as an advocate with a practice specializing in the trial of civil disputes. Ladies and gentlemen, the student community in Delhi till date very fondly remembers Justice N. Law for his 2016 decision in University of Oxford versus Rameswar Photocopy Services. This was a decision, ladies and gentlemen, where Justice N. Law had held that photocopying portions of books, especially textbooks and reference books, even if by a commercial photocopier for sale to students of a university, would not amount to the infringement of copyrights. Ladies and gentlemen, we are indeed very privileged to have these two gentlemen as our distinguished speakers for today's webinar. And to moderate this webinar, we are delighted to have two young stars of the Delhi Bar, Shashank Garg. Shashank is a young but very seasoned dispute resolution practitioner, and he's currently a partner with Advani & Co. He's also a member of the ICC Commission on Arbitration and ADR and is on the Arbitration Committee of the Delhi International Arbitration Center. He's a certified mediator and the author of two very popular law books, one on ADR and the other, interestingly, on tourism laws. Our second moderator is Kanika Singh. I dare not say anything about the beauty of Kanika, but as you can see, she is a young but very dynamic and articulate independent advocate practicing at the Delhi High Court. Without further ado, ladies and gentlemen, I now hand over this webinar to our star moderators for today. Shashank and Kanika, over to you.
Thank you, Ajay. Thank you for such an elaborate introduction to our distinguished panelists. Without wasting too much time, I'll kickstart the proceedings and would request Honorable Justice Enlow, who will cover his experience as a lawyer while covering the subject at hand, that is, the fundamentals of examination in chief and cross examination in a civil suit. Over to you, sir.
Hi, Shashank, thank you. And good afternoon to everybody. Mr. Thomas, you mentioned the photocopy case. Let me tell you that Justice Nandrajog was a appellate court in that. so you have the two courts which dealt with that matter before you. Of course, he was in a division bench with another judge, but he was the appellate court in that case. Now, friends, the stage of evidence, see, a lot of importance of that stage is being diluted now with most of the communications being in the electronic form, and which is really bringing down the importance of the stage. But still, a large number of issues, especially relating to non-commercial matters, remain, in which there is still a lot of importance of verbal evidence. Documentary evidence, I am proceeding on the premise that the documentary evidence, by and large, will now get over with the law, so we'll settle about the aspect of admissibility and proof. Now, why I say that this is a very important stage is for the reason that it is also perhaps the last stage at which you can correct the errors, if any, in your claim and defense. So it is always good to examine, because invariably the stage of evidence is reached after about 1 year of institution of the suit. So you are wiser even if you have yourself instituted the suit. During interaction with the client, a lot of other things may have come to your notice, or while preparing evidence, other facts or factors may come to your notice, which you may like to add if it is required to be incorporated in the pleadings. Now, what I also find is that evidence is not to be prepared merely by the pleadings. A lot of times what happens that the suits or the written statements are filed in a hurry, and the case law is not checked at that time, or the law is not fully studied. So one has to study the law all over again on the matter, and then with reference to the ingredients which the law requires for a particular claim or a particular defense to succeed, you have to see that which of those ingredients is admitted in by the opposite party, whether those ingredients are pleaded or not, and how best whatever is not admitted, whichever ingredient without which you cannot succeed, how it can be best proved. So all that work has to go before preparing the affidavit by way of examination in chief. The second important thing which I would like to highlight is that a lot of affidavits by way of examination in chief are today found to be verbatim copy of the pleadings. So it's always better to confer with the client and to dictate the affidavits by way of examination in chief in the presence of the witness whose affidavit is being drafted. Because a lot of times what I have experienced, that the witness may tell you that, no, I'm not going to say this, or I'll be caught on this if I put it like this. So then you have to change and say it in a different way. Then another stage which I find of leading evidence which is often neglected is tendering of the affidavit. by way of examination in chief. The stage of tendering assumes significance in the matter of proof of documents because at the time when the affidavit is prepared or affirmed, the documents are on the court record and are not there. So you may be required to identify the document, have the document identified by the witness in the court record and point the marks where the signatures identified by him are. So these are what I would say in a nutshell about the examination in chief. Now, cross-examination, I would just like to share. See, I've always felt that cross-examination is something which is very innate to a human being. We are all used to asking, we don't take anything for face value. Whenever we are told anything, we always ask why or how. Now, the only reason we are not able to do it so well relating to a professional client is because the facts don't relate to us. The facts relate to a third party, and unless we master the facts ourselves, we will not be able to review. So a cross-examination is literally to get into the skin of the client and to look at the facts from the eyes of the client. In fact, I have always maintained that cross-examination is taught to all of us right from kindergarten. I give the example of the poem which we are taught of Johnny Johnny Yes Papa. It, according to me, is nothing but cross-examination because the father of Johnny literally gets the truth out of the mouth of Johnny, who is denying the fact. So the purpose of cross-examination is that whatever has been deposed by the witness, which is not correct according to record, you have to lead the witness to take out that truth from him. And again, I emphasize that the cross-examination is always lacks. If there is a lack of communication, you don't sit down with the client or with the witnesses of the client who are in the know of facts to find out about the witness to be cross-examined on the next day. And that's why you are unable to not take out the truth from the witness. Only one other point I would like to make about the cross-examination. What has worked with me is to always prepare the notes for cross-examination, leaving it to one's memory to at the spur of the moment ask the questions, even if you know your meanings. According to me, often leaves a lot of lacunas because in cross-examination, not only what you ask is important, but the form in which you ask and the chronology in which you ask is very important. Unless you lead the witness to something after which what he has said contradicting you is obviously false, the witness, you cannot expect that if you put to him that what you are saying is wrong, it will at best be no, that is not correct. So this is what I would like to, what I feel are the basic principles to be remembered for examination and cross-examination. Thank you, Shashank.
Thank you, sir. May I now request Justice Nandajog, sir, if you could also give some of those interesting anecdotes which I had the occasion of hearing in some of our previous meetings would be very useful, including the story of that businessman wearing a dhoti, if I remember correctly.
Thank you, Justice Andlo, for having very well pen profiled the importance of examinations in chief and cross-examination at civil trials. I would just start like this, that when we say what should a plaint contain? Now, plaint should contain all statements of fact which, if traversed, would be required to be proved to sustain the claim. Therefore, it logically follows that in an examination in chief, all those facts which have been traversed are proved. Now you see, as it is said that in all human affairs, absolute certainty is a myth. And as Professor Brett said, all exactness is a fake. So the great writer E.L. Durando said that absolute proof being unattainable, it becomes the compulsion of law to accept probability as the touchstone on which we will determine whether a fact has been proved or has not been proved. And that is exactly what we find is the definition of the word proved. And in section 3 of the Indian Evidence Act, it says that where the trier of a fact in issue has a set of material before him, should he act on the supposition that the fact in dispute exists or not. So with these two fundamentals, we understand that examination in chief obviously has to be directed by the plaintiff to prove the facts in issue, and obviously an attempt by the defendant to disprove those facts in issue. As Justice Handlaw rightly pointed out, that in a very few civil cases, maybe like family disputes, talking of commercial disputes, we find everything is coming in the form of documentary evidence. So in family disputes where oral evidence is there, the examination in chief has to obviously center around the conduct of the parties. What was the course of conduct which they adopted before they came into the dispute, which obviously would be facts to the personal knowledge of those who had viewed the conduct. When it comes to documentary evidence, we have a very illuminating decision of the Supreme Court way back in 1958. It's reported as 1958 SCR Supreme Court Reports 328, Mubarak Ali Ahmed versus State of Bombay. That was a case where Mubarak Ali, when at Karachi, had held out to the complainant that he was possessing large quantities of rice. He took the money and he did not supply the rice. And the complaint was lodged, and obviously the trial centered around the documents which the complainant had handed over. They consisted of signed letters purportedly signed by Mubarak Ali. Some of them were unsigned communications. Some of them were telegrams. And how would you prove there was a problem? The partition had taken place. The Supreme Court said that proof of genuineness of a document is obviously a proof of the authorship of the document. And we find that 4 very illuminating guiding principles were laid down. The first was direct evidence by a person who saw the document being scribed or the signatures being affixed by the person who is purported to be the author of the document. Now, in such a case as Mubarak Ali's case, since the documents were prepared and transmitted from Karachi, there was no witness available. The Supreme Court said you could follow the next principle of internal evidence afforded by the contents of the document itself, where the disputed document purports to be a link in the chain of correspondence some links being proved to the satisfaction of the court. So even if some links are proved to the satisfaction of the court would then fall back upon the illustration of the under section 114 that the court may presume that ordinary course of business was followed. The third guiding principle laid down was general circumstances embooming the document in an appropriate case where it is established that the document constitutes a link in the chain of correspondence, and from this authorship could be determined. And obviously the fourth is expert evidence. Now today we find that most of the documentary evidence is electronically created, electronically stored, and electronically generated. How do we prove the genuineness of this document? Now, the flavor of electronically created documents could be numerous. It could be emails, web pages, text messages, digital voice recordings, database compilations, digital photographs, digital voices, computer logs, and call records. Now we have Section 2C of the Information Technology Act defines electronic record to mean data and all these things which I have spoken. We're talking of proof. Let's have a look to Section 61 to Section 65. They are relevant for the deal with proof of contents of document, primary and secondary evidence, with emphasis on proof of documents by primary evidence, with the contours of secondary evidence being as per Section 65, and Section 65A and 65B deal with the proof of documents. Now, Section 6 to Section 36 of the Evidence Act, which deal with facts which are relevant to the facts in issue, can be proved to determine a fact in issue. And a fact in issue, we all understand, is a fact affirmed by one side and denied by another side. With this theoretical framework created by the law of evidence, we must take into account that Order 18 Rule 4 of the Civil Procedure Code talks of affidavit by way of evidence. And keep in mind, as Justice Andlaw rightly pointed out, witnesses have to speak with reference to their personal knowledge. So Rule 9 of Order 19 stipulates that while drafting the affidavit by way of examination in chief, the witness must be deposing facts which are personal to his knowledge and thereby excludes hearsay, argumentative statements in the affidavit, and statements of law. In fact, Subrule 2 of Rule 3 of Order 19 casts an obligation on the court to not only impose costs and strike out those statements which are stated in the affidavit by way of evidence, which are hearsay, which are argumentative, and which are not to the personal knowledge of the witness. Having said that, it becomes a very, very simple exercise. But simple exercises, as Justice Andlaw rightly pointed out, needs hard work. You have to keep into account what law mandates to be proved for a claim to be sustained. And therefore, all such evidence, which is evidence of directly of the fact in issue or of a fact which is relevant to the fact in issue to be stated. Now, for example, the authorship of a document is an issue. And let's take the document has emanated from the defendants. The defendant scribed the document in his office, he signed the document in his office, and he transmitted it to the plaintiff. Unfortunately for the plaintiff, the dishonest defendant has denied the authorship of that document and obviously has denied that he transmitted the document. The plaintiff would have to prove two things: that the defendant scribed the document, executed the document, or got it scribed and signed the document and transmitted it to him. The fact that it was with the plaintiff itself is proof of the fact that such a document, unless it could be transmitted, unless the defendant says, well, I prepared it, but I didn't send it, and this fellow crawled into my office in the night and stole it. That situation apart, how would the plaintiff prove it? Very simple statements in the affidavit by way of evidence, that my first dealings with the defendant started in such and such year, and my first contract which was drawn up in his office. He signed that document in my presence and I recognize his signatures. So that document of the first contract would be relevant, because it's a relevant fact, because this witness now says that when that document was drawn up, the defendant signed it in my presence and I am familiar with his signatures. Then such other documents which bear the signatures of the defendant, for example, they may have had a meeting in relation to their contract. They drew up the minutes, which was signed in their presence. He must say that it was signed by the defendant, and he must then push in as many documents, not overloading the court, a good 8 or 10 of them, contemporaneous to the time when this document which the defendant has denied was executed, and tell the judge, and of course the law says that a judge can even visually look at the signatures on the admitted documents or such other documents which are proved by a witness to compare with this. Then coming to the transmission part of it. Well, you can give a notice under Order 12 Rule 8 to the defendant to produce his dispatch registers. After all, he's in business. And if he says, I don't maintain a dispatch register, the court will keep into mind that in ordinary course of business, people do maintain their dispatch registers if for no other reason to put into their expenditure the postal charges incurred in transmitting documents through post. Alternatively, the plaintiff can state that they in their office maintain, in the ordinary course of business, a receipt register. The extract of the receipt register would then be exhibited, because that would be personal to his knowledge, showing that on a date which the disputed document purports to bear, there is an entry in the receipt register in the plaintiff's office. So that is how, logically and simple as that, how would a reasonable human being infer a particular fact? So, for example, if you're walking down to the court in the Delhi High Court through the canteen, and at 10 o'clock you find a lawyer having a hearty breakfast, you're bound to say, aaj bhabhi ji ne khana nahi khilaya, you didn't have breakfast today. How are you inferring that he didn't have a breakfast? Because you are seeing him at 10 o'clock ordering a double egg omelette, a plate of bread pakora, and a plate of sandwiches, and gulping it down with hot coffee. So at base, as what Justice Andlaw rightly pointed out, what you really need to do is a proper client conference. On that, I would only have one thing to state. You have cases, I saw it as a lawyer many a times, while drafting a plaint or a written statement, I would normally quiz the plaintiff or such people whom the plaintiff wanted to cite as their witnesses. And all human beings are not the same. Some have feet of quicksand, they tend to slip, they get nervous. So I would always try to say that, can you substitute a better witness for me if in my chamber, in a non-hostile environment, the fellow is shaky. The fellow is so shaky, how do you expect such a witness to stand in a court of law? So having said that, just a word on cross-examination. By and large, your client has told you the truth. And the problem which the lawyer finds is that, unfortunately, in India, we are most unofficious when it comes to our commercial transactions, and which unfortunately I find is extremely true even for large multinational companies. There, if you find that there are certain gaps which are natural, which are capable of being explained as a result of the unofficious conduct, please do not try to puff up by putting in false facts. Let the natural gaps remain, and it's like joining the dots. So if 8 dots have to be joined, and if you find that in between 2 there is a gap, no issue on that, it'll get through. But to prepare for a cross-examination, so let's say your client tells you this part of the story is true, this part of the story is not true, it is now being pushed in by oral evidence. That is why you would see in the Delhi High Court you have Part A witnesses, Part B witnesses, Part C witnesses, Part D witnesses. A smart lawyer would always do, wherever there would be gaps, he would put in his Part D witnesses to fill up the gaps which would be there in the documentary evidence. Now, in such a case, good cross-examination. So I was in the second part of it. Many a times you find that a person says, I wrote the letter, but actually somebody else in his office had drafted that letter and he had penned his signatures onto that document. So he loosely says, I am the author of the document. He's an author of the document in a way, yes, because he has signed it, he's executed the document. But the scribe was somebody else. So you can now adopt a line of cross-examination to choose between discrediting the testimony of the witness or discrediting the witness himself. Because cross-examination says it has not to be restricted to the facts which the witness has deposed. You can put him all kinds of questions. You can confront him even with documents which have not been filed. Now, there if you find that the witness has signed the document but he has not scribed the document, lead him into it. Also, you call the steno and you dictated it, the witness will say, yes, I called my steno, or he'll say, I typed it myself because I'm very good. Become a linguistic expert. You have cases where people have this habit of making stupid spelling mistakes. Like, for example, lose. So LOSE is lost. LOOSE is lose. So if you're wearing a loose pant, you would lose your pants. So LOOSE, pants worn, would be a pant LOSE. So you'll find, so you write on a sheet of paper and just tell the witness. I don't find that kind of cross-examination being done. Is this sentence right? He will say, yes, it is right. Are the spellings of the words right? He will say right. And then you would find out and show that in this particular document, which he claims that he authored it, the spellings are not what this witness is saying. Time is short. But at base, what it emerges is that the hard work which starts at the drafting of your claim or your plaint, where all facts required to be proved is traversed, have to be pleaded, all those facts have to be proved. And the role of the lawyer on the other side is that such facts which are puffed up, which are false, which are untrue, to be demolished. Now, as Shashank, you said that that example, that anecdotes, and of course, no teaching is complete till you don't give some kinds of examples. I don't know, Justice Handlob would have also heard about that. This trader had engulfed the trade union leader into multifarious defamation suits, criminal and civil. So at a pre-charge evidence, the Lalaji came into the witness box. So he had to talk of defamation. So he had to talk of his standing in the society. So he said that I am the owner of so many factories. I'm the owner of so many properties. I pay so much of tax. I give so much money in charity. I'm involved in so many with so many charitable organizations, and I give so much donation to the charitable organizations. And then, of course, he said that at such and such place in the union, when the workers were present, he gave a very a speech against to the workmen. It was in a speech which was to rouse the workmen against me. He wanted to go on a strike and so on and so forth. So he said all that. So during cross-examination, the lawyer, the third question was, he said, Lalaji, ये जो धोती तुमने पहनी है, ये बास मार रही है, ये मैली है, ये 8 जगह से रफूड है और अभी भी 2 जगह से फटी हुई है. So the judge knew it was wrong, so the judge told the stenotype it. It is wrong to suggest that the dhoti which I am wearing hasn't been washed for 2 months. I deny that it is soiled. I deny that it is ruffled at 8 places, and I deny it is torn at 2 places. So when the stenotyped it, the judge said, what next? He said, no, my lord. Dhoti exhibit DW 1 by 1, a PW1/A. The dhoti has been now exhibited. At the stage of arguments, we will say, Lalaji, ab dhoti to utarni padegi. So he took out a gamcha and he told the Lalaji, ab aap gamcha pehen ke jayenge. The Lalaji had no option but to withdraw the civil suit, the criminal trial. Well, personally, I have seen as a lawyer also, I read one matter where ONGC was on the other side. It was an oil drilling contract where the American company people, everything went bad about that oil drilling and the blame game started. It was entirely the fault of my client. But there was only one thing which I was seeing in that case: would the lawyer on the other side catch it? Ditch magnets had to be put when the material from the core of the earth after the oil well was being drilled had to be pushed out by polymers, and then through a sieving tank it was pushed back once again, because the pressure of the polymer was also used for the kinetic energy to be using the movement of the bits. And at the catchment tank, the ditch magnets had to be put, and my client had not put the ditch magnets. And as a result, the little chippings from the rope, they call it, but it's actually in the nature of a pipe which is used to lower the bit into the well, and little metallic pieces which come out from the womb of the soil were re-entering and destroying the borehead. When the borehead was weak, it was just being drilled. One question, if had been put to my client: did you or did you not put the ditch magnets? So it again boils down to what Justice Sandlaw said. Every strand has to be picked up, sieved up, stitched up, and a neat packaging material. Unfortunately, what we are saying is nobody is looking at that gem inside. Everybody is so concerned with the packaging material of your plaint and the packaging material of your affidavit by way of evidence. I'm sorry to say, and Justice Sandlaw would agree with me, that 90% cases, the examination in chief is a verbatim reproduction of the plaint. That should not have happened. Thank you for having given me this opportunity to share one little anecdote and be a little legalistic about it, but I thought it was essential.
Thank you, sir. Yes, Honorable Justice Sandlaw, I believe you want to say something. So
I'm sorry, I was on mute. I didn't realize. Yeah.
Yes, sir.
Do we have time to share two instances?
Absolutely.
Which I think illustrate what I said about getting into the skin of the client very well. One of the cases is of the rent control era, when the bona fide requirement cases used to be contested tooth and nail. And my client was a corporate, and the landlady was residing with her granddaughter in Chandigarh. And the case for requirement was that the granddaughter has taken admission in Delhi University in a postgraduate course, and therefore they want to shift to their house in Basant Vihar. Now, there was no defense. The admission documents were there. I told my clients to check her attendance. Attendance was also there. But, every date when they used to come from Chandigarh to the court for the hearing, I used to notice that another young boy, he used to fly in. I knew he used to fly in because he proudly used to carry his J-class card in the top pocket of his shirt. And that girl, the granddaughter, and that boy, one could make out they would be talking to each other throughout. They were hardly bothered about the case. They would push off. I could overhear them to maidens for a coffee or whatever for lunch. So I asked my client that is she engaged to be married to this person? In a corporate, nobody is really concerned, so they couldn't find out. But when she came in the witness box, and this boy was also standing there, and I asked her that, are you engaged to this person? And she couldn't say no. And we succeeded in that case merely by that observation, which the client also did not know. Now, the other place where I suffered very badly, and perhaps that case must have been lost because I left it when I took up this job, was it was a suit for specific performance of a very big property in Narayana, and the sale consideration was very high. The plaintiff, I was for the defendant in that, the plaintiff used to come to the court along with his wife on each and every date of hearing. And from the attire of the plaintiff and his wife, nobody could say that he would have that 20 crores, 25 crores for which he had agreed to purchase, entered into the agreement to purchase. And the state of pleadings in the documents was very, very poor. His advocate had not said anything. Even in examination in chief, he did not say anything at all, except for saying that I have the sources. No document was proved. And I was so misguided by his appearance that I kept on asking. He always used to carry a leather bag with him. I don't know whether you people have noticed, not any fancy, just a leather bag which a lot of elderly residents used to carry at that time. And I asked him about he said that, did you have a bank account at that stage? He said, yes. But are you carrying the passport? See, his lawyer was not wise, but he was very wise. Each and every document came out from that leather bag, and I was totally demolished. I damaged my own case. So I'm just telling you that how the cross-examination or the evidence can work wonder, or it can also sometimes, without proper information, damage one's case. Sorry, I took up some time.
Thank you, sir. Thank you for those examples, and thank you, Honorable Justice Nandalok, for this succinct overview of the statutory provisions as well as the anecdotes, which helped us understand a little better. Now, just moving on straight away to some questions, which hopefully would help us understand this a little more better. My first question is to Honorable Justice Enloe. So the question is, and this is a little basic and stemming from what you had said about the importance of the stage of tendering and marking your documents. What questions can the lawyer of a witness, what questions can the lawyer of the opposite party, say if it's the defendant in case of the plaintiff's witness, take with regards to objecting of tendering of documents other than mode of proof? And there's also another question merging with that. Other than mode of proof, sir.
Yes.
And so there's also another question, which has also come from the audience, which I'm keeping with this question only, is that how fatal is not objecting to exhibiting of documents when some judgments, including the judgment of the Honorable Delhi High Court in Sudhir Engineering versus NITCO Roadways, has held that exhibiting will not mean proof of the documents, and anyway those documents would have to be proved. So if my lords can consider answering these questions.
See, the first question, the objections can be qua non-admissibility. Non-admissibility can be on the ground of non-stamping or non-registration. They can be on the ground of the document having not been filed at the proper stage. That can be another, because primarily all these objections are about the mode of proof. But you are asking besides the mode of proof. Another objection can be that the document is not primary evidence and the notice to produce and the original has not been given. Then nowadays, in the context of electronic evidence, objection can also be that the 65B certificate is not there. Then, though that's not very common, but there can be objection about privilege. For instance, if the document relates to a communication between spouses or communication between the lawyer and the client. So this is what immediately comes to my mind. These are the few other grounds besides mode of proof. Yes, one other can be this, though it's the law with respect to that is not very clear in India as yet, but that the document has been procured illegally. So that doctrine which is there of fruit of a forbidden tree. So that is also required to be taken. Now, as far as the effect of not taking that objection is concerned, see, there are some matters which go to the very root. For instance, if a document is not stamped or not registered and it is barred from being admitted into evidence, not taking the objection at that stage may not be so relevant. But a lot of other grounds, they would stand waived if you don't raise an objection at that stage. So it is, according to me, very important, because if you had taken the objection, the argument would be that perhaps the opposite party would have got the document proved in a better way or in a proper way, but you allowed the document to be admitted into evidence without objecting to it. So therefore, at the stage of final arguments, you cannot take that objection. So it depends upon the nature of the objection. Primary or secondary, my view is that you can lose that right once you do not object to a secondary evidence document being taken on record. So always safest to take the objection.
Thank you, sir. Shashank?
Yeah,
I would
I
just like to
have a
add
question
one
for
thing on Kanika.
Justice Nandagopa.
Just one thing to add on what Kanika said. Kanika, a lot of lawyers have a very wrong opinion. If a document is exhibited and it is proved, it doesn't mean that the contents of the documents are also proved. For example, in a matter where a plaintiff had made wrong assertions of the current facts to the defendant, like for example, the plaintiff says in a letter that on such and such date, when I went to the defendant's factory to see whether the defendant is in the state of preparedness to supply the goods to me, which was 3 days off from the date of the contract, I found that his factory was closed. And the man at the gate told me, he said, this factory is lying closed for 10 days. That letter has been sent. The defendant says this was a mischievous letter sent by him. He knew I was in the state of preparedness. This guy didn't have the money. The document would be exhibited. The document would be proved. But that doesn't mean that the plaintiff's assertion that when he went to the defendant's factory 3 days prior, he found that the factory was closed. So we must draw these distinctions. That the proof of a document is the proof of the contents of the document, limited only that yes, this document has that content. Whether the assertion of that content is correct or not is little different. That's why, we say in the Delhi High Court, document admitted, contents denied, document admitted, contents denied. It was in this context when it was
Right. Thanks.
So,
Shashank, you want to take the
here's
next
a
question?
question for you, for Justice Nandajog. If during cross-examination, a witness makes a statement contradictory to the affidavit, should the counsel confront the witness there and then, or should he wait to address this during the final arguments to show that the testimony of the witness was colored as he was giving contradictory statements? Because giving him an opportunity at that stage could be fatal. Your views?
Of course, it would be extremely fatal. If a witness, law only states that if a witness has made a previous statement and you want to use that previous statement against the witness, then law says that you have to confront the witness with the previous statement and he can explain that under what circumstances he made the statement. But if, as a part of his examination in chief and cross-examination, he contradicts himself, then I think it would be fatal to keep on asking the witness further supplementary questions and giving the witness an opportunity to correct it. You should leave your cross-examination there and then.
Just a follow-up on that, requesting Justice Enloe to comment. Sir, where do we draw a line between tutoring the witness and preparing the witness? Not just the ethical line, but also practical line.
See, tutoring the witness would be to tell him to say something which is which is not a fact, or what he has told you is not the fact. So tutoring, according to me, is confined to that only. But preparing a witness is a very important stage. According to me, if we put a person who is not used to the court in the witness box, we are all used to, in our daily conversation, we don't give reply in full sentences. We would say somebody said, "Is that correct?" You'd say, "Yeah." So when the answers are recorded, because in the court generally it is recorded verbatim what the witness has said. A lot of courts are now recording evidence in question answer form. So at the stage of final arguments, when you reach such answers, the testimony, it doesn't give the ring of truth for the judges or the arbitrators to act on the basis of that. So it is always better to tell the witness to the manner in which it is to be answered, to understand. A lot of us, we respond. We are all very bad listeners. The anxiety is always to speak and to give an answer without fully understanding the question. So preparing a witness, telling him that listen carefully, telling him that look, this suggestions will be put, because that, though I am of the view that suggestions serve no purpose, but unfortunately that remains the cross-examination to a large extent today. So all this is the witness is not used to a person coming to the court for the first time, and he takes a lot of things which are in his mind to be a given, and that I have engaged an advocate, he will say all this. So the person needs to be told before going to the court that look, this is how it is going to play out. So you have to answer, so that what is being written, you have to follow both that what is written is what according to you had happened. When we read that after 5 years, we should be able to understand that yes, this had happened, rather than leaving it ambiguous. So there is a vital difference, and there is no harm in preparing a witness. All that is prohibited is that you should not tell him to tell a lie.
Right.
Absolutely. Thank you, sir. So my next question is to Justice Nandrajog, and it's a little topical given today's scenarios. So the question is, given today's scenario with the emphasis on virtual hearings, do you think cross-examination with its little nuances that are to be observed with regards to the demeanor of a witness, as well as the idea of putting the witness in a formal setting to elicit honest responses, do you think that get compromised in a virtual hearing perspective? And would it be possible to have cross-examinations on a virtual hearing platform?
Let me answer it by prefacing one thing. The concept of a demeanor of a witness is relevant when the judge who's authoring the final judgment is the judge who has recorded the evidence, and he has seen the demeanor of the witness, which while writing the judgment, he would use. I haven't come across in the last now 30 years any judgment being authored by any judge anywhere in the country where the judge has referred to the demeanor of the witness. And unfortunately, the reason is that the recording of evidence itself takes so much time that more than one judge tenure gets over. Number two, now in civil trials, I don't find evidence being recorded in the court. It's all before the commissioners. So this concept of a demeanor has in any case being lost. So whether it is in a virtual cross-examination going place, or it is taking place before the court commission. So to that extent, the issue of demeanor becomes a non-demeanor. The only problem could be confronting the document to a witness, a correction made, a typo error corrected, or to read out a particular line and confront the witness. Theoretically, it is possible that the document can also be then loaded on, shown, and if you want to confront the witness with 2 lines, you can highlight those 2 lines, but it would make it extremely cumbersome. And one thing is there, we have seen that in an environment which is away from the court, the witnesses it'd be very easy for a witness to tell a lie. People have a lot of issues. Why do you have the grandeur of the court? Why should the judge be sitting on a dais? Why should the judge be wearing black clothes, white shirt, and a band? You know, that degree of formality itself sends a signal to the witness that it's a solemn place. But otherwise, I think theoretically it would be possible, but it would not be desirable.
Thank you, sir. So my next question.
May I just add to that?
Right.
See, I feel doing the cross-examination virtually would literally destroy, then we might as well not do the cross-examination. Again, speaking from personal experience, I invariably in all important trials, and particularly the party witnesses who had never been to the court earlier, now I'm talking of the corporates where the person who is to actually depose the director, they generally don't come to the court at the preliminary stage. They come to the court only for the purposes of their evidence, because in the facts maybe no officer can give evidence. So what I have experienced with it, so I always used to tell them that, look, if you want to see what is a court like, how does it happen, come one day earlier. So I would call them one day for half an hour just to show them the court and all. And I have had, I would say at least half a dozen of those witnesses when they had, before that, when I was preparing them for their examination in chief, that time the examination in chief also used to be in the court, not by way of affidavit. So, you know, they said, no, sorry, I cannot make that statement. I am not going to lie on oath before a judge. So what Justice Nandrajog said, that the impacting what is cross-examination? Cross-examination, like I was giving the example of Johnny Yes Papa, is Johnny had said that he is not eating sugar. He doesn't have sugar in his mouth. But in cross-examination, he was told to open his mouth and out came the sugar. So when you have to do that, it's a mind game between the cross-examiner and the witness. And my experience has been, we have debated this in the courts, and a lot of my colleagues differed with me, that it makes a difference, because if you people are familiar with the district courts or even in the high court, the witness box is always a little higher than where the lawyer stands. So I have noticed that it makes a difference whether the witness is standing higher than the cross-examining lawyer. So generally, I used to prefer to stand myself in the witness box and make them, because I in any case have a short height, so there was no way I could tower over the witness. So it's best to stand yourself in the witness box, put the witness outside, and then cross-examine him. Similarly, that whole thing of the judge's presence, a formal atmosphere, even if you are getting the statement recorded from the stenographer or the typist or before a commissioner, all that makes a difference. So according to me, we are not ready in this stage where speaking a lie in the court is a norm. We are not ready, according to me, for cross-examination through video conferences, because sitting in my own home, in my own chair, I would have no hesitation in saying anything. That is why in the rules which have been made for recording of evidence of witnesses via video conferencing, which till now we have confined generally to foreign witnesses or outstation witnesses who are unable to come to the court or to travel, we have provided for the cross-examination to be conducted in the presence of either a oath commissioner or a notary public or before the Indian Embassy or the High Commissioner, so that the witness goes out of his comfort space into another space and then deposes. For instance, if I am to ask Shashank something, I don't even know whether he is reading out from somewhere or somebody is sitting behind his chair holding a gun to him that Shashank, you have to speak like this. So all that is possible. If I don't want him to speak the truth, I would send somebody to his house and hold him to ransom to speak in my favor. Justice Nandanjog wanted to say.
I wanted to say one thing. All this is good in theory, but Justice Handlaw would agree with me. I have seen now that in commercial civil litigation, the final arguments, there is no reference to the testimony of the witnesses at all. The entire argument says, so the contract is admitted, so no dispute on that. In the working of the contract, this is what is in dispute. Kindly see, I have written this letter to the other side. Receipt of the letter is admitted because with reference to my letter having reference number, the defendant has given a reply where out of 4 assertions of fact made by me in my letter, which is exhibit P1, he has only controverted 2. 2 he has not. See my response, which he admits because he's filed this document. My response is dealing with his response to only 2. And then the next letter in the sequence, while giving the response, he dilutes his response to point number 1, which he disputed. This is what is going on. So today, I think we also have to put a question. Do we need examination in chief? Do we need cross-examination? When at the end of the day, it will all be sorted out with reference to the contents of the emails, the letters, the telegrams, the minutes of the meeting which have been dropped. Much of it is becoming totally irrelevant. I'm not finding any judgments in commercial contracts with testimonies of the witnesses. Few, very few cases. And that also maybe 0.5% of the disputed fact being talked about. So I think if we all put our heads together, it's quite possible. And I don't know how long this COVID issue will go, how long the actual court sittings would not take place. The vaccine may not come. It's staring us in the face. So can we have no trials for the next 2 years? I doubt.
My next question is to Justice Handlaw, and I'm taking a little cue from what Justice Nandanjog said with regards to what has become superfluous. And Justice Handlaw's views on this are a little clear with regards to the scope of suggestions in a civil trial. And Sir has also authored the judgment. So I just wanted to know, sir, do you think there are still any particular instances where suggestions would have a vital role to play in a civil trial? Or they are something that should be completely not looked at and should not be preferred and can be completely ignored?
See, to a limited extent, maybe depending upon the facts. Immediately, I am unable to come up with any instance in which suggestion may be required. But otherwise, what is required to be done is to, instead of just putting to the witness that what you have said is wrong, you have to ask him the surrounding facts about which he may not have been told, prepared, as I said, that you have to be cautious about it, and to which he would answer correctly. And After he has reached a particular stage, then if you give a suggestion and if even if he reiterates his earlier statement, then at the stage of argument you can argue that look, this answer is obviously false in the light of other answers which he has given or the improbability of it. Else, according to me, it's a waste of time. But let's have Justice Nandaraj's view on this. I have already opined on it.
So I have a question.
Yes.
Justice Nandaraj, are you adding to
Yes.
what Justice Endlo stated, or should I ask the?
You see, I was only saying that theoretically suggestions have relevance. Theoretically, it is possible that even in a documentary evidence, examination in chief and cross-examination would have relevance. It depends upon the skill of the lawyer. Like, for example, I go back to that little example which I gave, that a plaintiff relies upon his letter where he has made assertion of 4 facts, and in a response there is no denial and no traverse of 2, there's an explanation of 2. Let's take it's a contract and the reply is sent by the engineer. It's possible for you to make the engineer say that, look, this letter was placed before me to be replied with reference to the engineering aspect of the issue which was raised. These 2 are relating to the commercial aspect of it. And so therefore, when I replied to this, I replied to only these 2. It's possible. So we can't really generalize, but what I'm trying to say is, as we said, absolute justice eludes us. And what is happening is we have to also determine good justice, timely justice. So when we talked about absolute truth evades, therefore preponderance of probability. So let's also accept if absolute truth evades and law accepts preponderance of probability, then why are we looking to absolute judgments? And in the process, we are making it so time consuming. Industry must take this risk and it's worth it. So if you have 99 quick judgments and 1 you've gone wrong, accept it, because where is the proof that the other 99 with the full trial are also correct?
So the next question is with respect to introduction of a document. So I am blending 2 questions in one. One we have received from Mr. Pradeep Devan, senior advocate. So if re-examination is permitted for explanation of matters referred to in a cross-examination, can a witness introduce a document by way of such explanation in re-examination? And what would become of such a document? Second, question which is blended with it is at the stage of a cross-examination, can under Order 13, Rule 13 of CPC, any document be put to the witness even if he is not a signatory or a party to it, as the witness may by his personal knowledge admit the document. Further, if the witness doesn't admit it, can the document be placed on court file without being received in evidence?
Right.
Either
So
of the panelists.
let me answer the second part, which is very simple. During cross-examination, you can confront a witness with any document, but subject to the objection that the document must relate to the witness. It may not relate to the examination in chief of the witness. Now, for example, the witness is from the accounts department of a company, and he says that only 22 bills were received in the accounts department to be cleared for payment. And the defendant's case is that he had made delivery under 22 bills. So a witness says that in the ordinary course of conduct of the business of our company, all bills are sent to the accounts department, and the accounts department then checks the price of the bill with the price under the contract. And when a person certifies that the bill is as per the price, then we send it to the stores department for the response that the goods are as per the specific specifications in the contract. Now, if the suggestion relates to the specification, the lawyer should object that it doesn't relate to the witness. But if it relates to the witness, then surely the document has to be brought on record, and the witness denies, it will be a marked document. Why? Because during argument, you'll have to show to the judge which was the particular document. I've come across cases where the witness was confronted with the document, the witness had denied it, the document was not taken on record, and the appellate court was always at sea what was the particular document, and the argument was the witness is lying. So you see, we'll really have to see in a particular circumstance of which it is. The second part, the first part of the question, that if during cross-examination a document which is not on the file is produced and the witness admits the document, then we always have, don't we have in cross-examination volunteers, the witness volunteers? Yes, but there was another document which dealt with this document and I can produce it. Or for example, if the witness is already there with his file and he's deposing to proof of documents which have been filed, he can surely pick out the document from his file that in response to this document which has been now put to me to contradict me or to confront me, this document exists, he can surely bring it on record. Because let's all understand, what is it all about? It's all about fairness and logic. As long as there is fairness and there is logic, the whole civil procedure code, the law of evidence, is always moving in the line of, as we say, to find that nugget of truth, and that's the job of the judge. I hope I've answered both your questions.
Sir.
So my next question is to Justice Enloe, and this is a question that has come from Mr. Abhijat. His question is that the Evidence Act permits questions to shake the credibility of a witness. However, is there a fine line between doing so and asking questions which would be in the nature of harassing a witness?
Yes, it is. Of course, there is a fine line, and Evidence Act also has a provision which says that which questions the witness can be compelled to answer and which he may not be compelled to answer. But again, you see, what has happened is that the way in which evidence is going on today, or either before the joint registrars or before the commissioner, and the way the law has developed, that every question is permitted to be put, and only the objection to that is got recorded. And even if the objecting counsel gets the matter listed before the court for resolution, a number of times the factor of expediency, because either one starts hearing the entire suit at that stage, you have to go through the evidence. So generally what is happening is that the courts also say that no, we'll consider it at the final stage only. Before the district courts, one factor is that at the appellate stage, one never knows that what view will be taken. So therefore, we are rarely or very sparingly using that provision of not permitting the questions which are found to be intended to harass the witness and not to test the veracity or the credibility of the witness.
Thank you.
So,
I'll just add with reference to an example. Let us take a case where the witness says that after the discussions took place, the discussion started on the draft of an agreement which the defendant had brought, and after on discussing, making corrections, additions and deletions in the draft, the final type printout of the document was taken out in the plaintiff's office, at 6 o'clock in the evening, and it was duly signed. This is one. The second is that the witness is general, the discussions went on. They went on and on and on and on and on. He doesn't give the time and he doesn't give everything. And then he says that this document was finally scribed, it was drawn up, and it was signed. Now, in second situation, if in cross-examination, the witness is I put it to you that the discussions went on in the hotel till late night and you broke for dinner. And the witness says, yes. Now the witness neck is in your hand. If you ask the witness, have you been treated for alcoholism? And the fellow has been. He said, this guy knows I have. He says, yes. Is it correct that you were prone to alcoholism in the month of July? Yes. Is it a fact that when you would see alcohol, you would go in for nothing less than 6 pegs? The guy laughs. Now here you are discrediting the creditworthiness of the witness. Why? Because this document, as per him, was finalized after they had had a dinner. He was alcoholic at that stage. He has admitted that he took 6 to 8 pegs of alcohol. So they are good argument and good cross-examination permissible. But suppose it is at 6 in the evening, then somebody would say, I'm not permitting you to cross-examine. It's got nothing to do with his being an alcoholic. It's got nothing to do until and unless you suggest that, look, even at 4 o'clock you used to start drinking. So you see, it all depends, but law permits the cross-examination to discredit the testimony of the witness or to discredit the witness himself. And when you say the witness is being discredited, it actually means this.
So the next question I'm taking is from Mr. JP Singh, senior advocate. He's asking if a witness is to be disbelieved because of the cross-examination, or if he fails during the cross-examination, can the party examine another witness on the same facts?
Well, it's like this. If the party has given in the list of witnesses the names of the witnesses, then I think civil law prohibits substituting your witness. Huge prejudice would be caused to the other side, because then the other witness would be tutored. That is why you see a good lawyer where 2 witnesses are deposing on the same set of facts takes the permission of the court not to cross-examine the first witness. He says, let the other witness also depose and I will cross-examine both the witnesses together. So the answer would be, you cannot substitute your witness if your witness is discredited during cross-examination, because the possibility of a tutored witness who would come prepared to fill up those gaps would be very heavy. And let's not forget, the stage at which you introduce your witness itself is used by the lawyers to argue that the witness is discredited, because he's been introduced at a stage when a particular witness has already been discredited.
Okay. Thank you, sir. So my next question is to Justice Enloe, sir, and I'm probably going to be clubbing 2 questions. So the first question is, if a witness, in response to a question in the cross-examination early on, admits that he's not read the contents of his affidavit of evidence before signing it, or admits that they are not to his personal knowledge, would a counsel in such a scenario be well advised to continue with the cross-examination on merits of the said affidavit of evidence, or should he stop there? And a follow-up to the question is also, so do standard cross-examination questions that we've often heard as to where did you sign this, to elicit a response whether you signed it before a notary or not, do they serve any purpose? So I'm just clubbing these 2 questions together, sir.
If the witness has, in response to the initial questioning, said that he has not read the affidavit or he is not aware of the contents, according to me, the best course is to put a stop immediately to further cross-examination, because if the witness is otherwise aware of the facts and is truthful, and you cross-examine him on the contents and he gives the correct answer, so then that his case would be fortified. The golden rule of cross-examination is not to ask a question, the answer to which you don't know what that witness will give. So we see a lot of excessive cross-examination now. So cross-examination is equally important about where to stop, then as important as what to ask and how much to ask. Now the second, the view taken by most of the courts, according to me, is that those questions about did you go to the oath commissioner or the notary, where was the affidavit prepared, they don't really take us anywhere, because the practice, as this is a classic case of where the practice has overtaken the law. The practice, we all know how it happens, that the affidavits are, as Justice Nandrajog said earlier, the affidavits are verbatim repetition of the pleadings. In fact, in a large number of cases, I have also found the paragraphs relating to cause of action, territorial jurisdiction, valuation in the affidavit, and one, of course, was an extreme case where the advocate for the defendant, that was the defendant's affidavit, he also said that this judgment holds this judgment holds this, and the judgments were also annexed to the affidavit. And when the lawyer was asked about it, he said, "You think I'm going to come to address final arguments now? Whatever I had to say, I said in this." So in that asking, so unless it's a some special facts of that case give you an additional advantage by asking all that, according to me, those questions need not be asked. That did you go to the oath commissioner? Where was the affidavit prepared? It's best to proceed with the merits.
So seeing
I
Ajay
think,
back,
Mr. Thomas, probably we are running out of time.
yes, seeing Ajay back on the screen is a cue for us. In fact, the number of questions we have received, over 100 questions. So I think we will have to do a sequel of this in the near future to answer all those interesting questions that we have received. But for the time being, because of the paucity of time, we will have to put a hard stop. I am grateful to Honorable Justice Endlaw and Honorable Justice Pradeep Nandrajog for sparing time and addressing this fundamental issue, which us as young lawyers and many seasoned practitioners face in day-to-day practice. And I'm also grateful to Kanika, my able co-moderator, for conducting these proceedings with me. And many thanks to Manu Rachna University and Ajay Thomas for providing all the support and help. Thank you, everyone. Hopefully, we'll meet soon if the panelists agree for a sequel.
Thank you. Look forward to.
We don't look at nursery rhymes the same way again. Thank you, sir.
Seeing everybody in person, so that we can do some personal cross-examination of each other.